Supplementary list, item number 1 for pronouncement of judgment.
I'll read out only the operative portion. Accordingly, the impugned communication dated so and so is hereby set aside and quashed. The service of the petitioner is not to be dispensed with at this juncture, but it is left open to the respondent's managing committee to comply with the policies of the school as far as employment of teachers is concerned, however, by following due procedure. In the event this petition is hereby disposed of, no cause.
Please, Lordship. Lordship, I beg to mention item number 4. Lordship, conducting counsel is indisposed, Lordship.
Amid business, Lordship.
Yes.
Lordship, if 4 goes, then 3 also will go.
You are appearing in 4, Lordship, but who is appearing in 3?
3 we are appearing.
You are also seeking.
No, my lord, we are.
Then we'll hear
Because it's a common issue, Your Lordship. It's a common issue.
maybe common issue, but you see, the counsel for the petitioners are separate or different. Facts would remain the same, but they may have a different
It's true,
view.
Your Lordship, but the issue is same, Your Lordship. Unauthorized occupation of government land, forest land. They come together, Your Lordship.
Is the counsel for the petitioner? For the you are for petitioner?
Petitioner, Lordship, in case 153 of 2021.
Who's leading you in this case?
Sir T.T. Dingdo, Lordship.
What is your name?
He's indisposed, Lordship.
Has sought for accommodation on the ground that the learned senior counsel, Mr. T.D. Dingdo, who is leading the case, is indisposed. The prayer not being objected to by the respondent, matters adjourned. List the same after 1 week. 1 week.
1 week.
All matter.
Lordship. So also item 3, Lordship, will take together, Your Lordship.
Waiting for his agent.
This is matter after 1 week.
Lordship, yes. Along with Lordship. Apply, Lordship.
Lordship, similar prayer for item 5, Lordship.
And things left.
Lordship,
Senior counsel is
indisposed.
Kajuk order, no?
Highly obliged, Lordship.
Apply, Lordship.
Can you, I know, 2 weeks. 2 weeks, Lordship. Highly obliged.
Supplementary list, item number 2.
Wait, please, my lords. My lords, this is an application for pre-arrest bail. My lords will find the FIR. Now what happened? Pursuant to delivery of these products, I have raised certain bills which start at 29. These invoices were raised for the various products which were given, installation, maintenance. Now out of this, there is still a pending payment of 1.25 crore. This was not paid. Now this is a contract of 2022. I have already done my supply. The company has already supplied, company has installed, and company was maintaining it also. And during maintenance, we used to ourselves take out some wires and replace with new wires. Now, while this was happening from 2022, there was no dispute. When I was maintaining it from 2022 till the date of FIR, there was no dispute. Now, suddenly because of non-payment, I said that I am not going to supply you anymore. As soon as I say that, the FIR is filed. And in the FIR, they say that I have taken away wires. Nobody has taken away wires. This was being regularly maintained. And as far as this applicant is concerned, he was not even present. He is in Pune. Now, thirdly, after the FIR at page 32, they issued a notice under 35.3.
What is your capacity in the company?
I am a project manager.
Project manager.
I am a project manager of the company. That, if I may read, well, at para 1, page 2, I have said what I am. The applicant is a permanent resident of Pune and has deep roots in community. Applicant is a respectable member of society with no criminal record. The applicant is an engineer professional for last 15 years of experience in corporate world and is currently employed at Pune. At present, the applicant is leader customer advocacy from 2018 at so-and-so company. Now at page 32 is the notice which is issued to me, asking me to be present on 19th of May. My lords will find 19th of May at middle of the page.
Yes.
This was received by me on 14th of May and I replied, because I could not come, I replied at page 34. Page 34, if I may read the second last sentence, second last paragraph. I understand the importance of complying with legal obligations. I am committed to cooperating fully. Therefore, I respectfully request you a rescheduling of my appearance to a later date, preferably after 20th of June. I don't receive any reply to this. So I apply before the Bombay High Court for transit pre-arrest, which is granted to me, page 68. But the Bombay High Court does not go on the merits. It's just a transit to come before a court of appropriate jurisdiction. I am before my lords. I was given 2 weeks time. That was getting over yesterday. I have moved the application yesterday and I mentioned it yesterday. So all that I am saying, I'll cooperate. I should be protected. I'll cooperate. Whatever conditions is imposed, I'll appear in the next 7 to 10 days and I'll produce all documents, whatever is required. But the thrust of my application is that on 5th of March, when the alleged incident took place, I was not here. I am a permanent resident of Pune. And 305 and 324, in my respectful submission, will trigger against the person who commits that act. If I am not even here, I could not have committed that act. And I am a permanent resident. I have put my Aadhaar and PAN card as annexure 1. My permanent address is shown as Pune. My lords will find my Aadhaar at page 21. And at 22, my address is the bottom of 22. Rajiv Gandhi Nagar, Koregaon Park, Pune City, Pune.
Yes, Mr.
Yes, my lord. I've gone through the order, interim order passed, my lord. My lord, it was granted 2 weeks time, my lord. So I believe the petition has come fairly, my lord. So I leave it to the discussion of this honorable court. But in the meantime, let the IO furnish a status report within the next week, my lord, to this court, my lord.
Why?
If they have cooperated with the investigation or not, my lord.
See, what is the import of a notice issued under section 35? It is for securing the attendance of any person said to be connected with any offence alleged to have been committed. So he has been issued with this notice. He has sought for accommodation. No response was forthcoming.
Absolutely, my lord.
We don't know what the IO did after that.
My
Whether
lord,
any report was furnished to the magistrate, whether any order of arrest was made, that is not known.
that is why, my lord, I was seeking that.
So, on that, you see, on that ground, apprehension cannot be presumed. You've come,
My lord?
you have come primarily based on your apprehension of being arrested.
Yes.
But there is no scope for your arrest. If you look at as I said earlier, purport of section 35, it is a notice that is issued.
Yes.
If you had appeared and anything or any material found against you by the IO, what he will do is he will forward the report to the magistrate who will pass an order for your arrest. At that point of time, maybe you can approach the court. But here is a case where nothing is.
So, all that I am saying, if I am protected in the interim, let the application be pending.
Where is the apprehension? The IO has never stated that you are likely to be arrested. Is there any report
No, my lord.
to that effect? He has just summoned you. One mean you can come at any time that has been fixed.
So, all that I am saying, my lord, I am saying that the date may be fixed for me to appear before the IO. Till then, I may be protected. I may be protected in the interim. Let this application be pending. I have moved an MC. I may be granted interim protection. I will appear. I will give the documents. Then let IO give a report. Because there is an underlying contractual dispute.
Whatever the case may be, this court will not go into the merits of the case as of now.
But well, on the prima facie count that I was not even present on the day of the incident.
That would be your ground. The IO may say otherwise.
But I have shown prima facie that my address is in Pune.
Where is the FIR again?
Well, it's page 23. And page 24 is the relevant part. May I give a clear copy? Type copy.
Yes, ma'am. An FIR was lodged before the officer in charge, Sadar Police Station, Shillong. On when was the FIR lodged?
Well, it's on 6th of March 2025.
6 March 2025 by one Mr. What's his name?
I'll just give his name.
Anshit Roy.
Anshit Raj Kakkar.
Anshit Raj Kakkar
Kakkar.
of representing Nice Infotech. No. Wherein an allegation was made that wires connected to the VMDS capital no VMDS located at Old Assembly DC office and additional secretariat were found missing on being checked by the complainant and his team. Therefore, the said FIR was filed on the ground that theft has been committed. In course of investigation, on the case being registered as, what is the case being registered as?
64 of 2025. 64,
Sadar PS case number what?
64,
3 of 2025.
64 3 of 2025.
Under section
305E stroke 324 3
And 5.
5 BNS Act.
3 and 5. Move it on.
Page 32, my lord. In the notice.
Atau puli ganti lain no. This is notice under section
35.3
35 and bracket 3
of BNNS.
of
BNSS.
NSS was issued upon the petitioner. Where's the notice? Page?
Page 32.
Directing him to appear before the IO on 19/5/2025. The petitioner, is it petitioner or applicant?
Applicant.
The applicant has replied to the said notice by a communication dated
4/6/25.
4/6/2025 seeking rescheduling of the
Appearance.
date of his appearance, since he is a resident of Pune,
Pune, Maharashtra.
in the state of Maharashtra, and could not appear on the said date fixed. However, in the meantime, apprehending arrest in connection with the said RPS case, the applicant had approached the Honorable Bombay High Court with an application seeking transit bail to allow him to appear before a competent court of jurisdiction in the state of Meghalaya. The by order dated, is the order
10 June 2025, page 68.
10 June 2025. The applicant was allowed by the Honorable Bombay High Court to appear before this court. To appear, have you specifically said before this court?
No, at page 70,
Before, to appear before
The competent court.
competent court.
competent court in the state of Meghalaya, and for which he was granted transit bail.
2 weeks.
Next, the period of transit bail being exhausted, the applicant has now approached this court with this instant application seeking grant of pre-arrest bail. Mr. Learned Counsel for the applicant has submitted that that presumably the genesis of the dispute leading to the lodgement of the FIR is a contractual relationship, is a breach of a contractual relationship between Nice Infotech and Adore Powertron Limited, Pune, of which the applicant is
An employee.
an employee of such company in the capacity of, what is his capacity you said
I'll
again?
just give me this. Leader, customer advocacy.
Leader customer advocacy. There appears to be some dispute between the parties named herein above as regard maintenance of what are those things called?
Well, these are called. I'll give the full name. Variable messaging signs.
Variable messaging signs which were put up in
Multiple locations.
multiple locations, visible through signboards. It is the applicant's company which is maintaining the functioning of such variable messaging signboards or signs.
Signs.
However, on dispute regarding payment for which the complainant's company is to make to the company, to the applicant's company. Therefore, on some vague allegation, the applicant's company was alleged to have been the cause of such theft. Though nothing specific is known, this is in the realm of speculation as far as the applicant is concerned. However, the Learned Counsel has submitted that since the said notice under section 35(3) BNS has been issued, there is every apprehension for his arrest in the near future, for which this court is accordingly petitioned for grant of pre-arrest bail with any condition that is deemed fit and proper. It is the further contention submission of the learned counsel that the applicant is a permanent resident of Pune with no criminal antecedent, and if enlarged on bail, he is willing to abide by any condition imposed by this court and would cooperate with the investigation of the case. Mr. S. Sengupta, learned additional PP, has submitted that prima facie there appears to be the case of the applicant appears to be genuine, inasmuch as the said notice under section 35(3) being issued, comma, the applicant failing to respond to the same, there is every possibility that the IO would follow up with an appropriate order, even to the extent that an order for arrest of the applicant may be made by the competent authority. It is, however, Mr. Sengupta has, however, left the matter to the discretion of the court as far as consideration of this application is concerned. This court has considered the submission and contention made by the parties. Facts as stated need not be reiterated. Suffice it to say that prima facie there appears to be an allegation of theft of the property of the complainant's company. Nothing is forthcoming as far as the investigation is concerned as to who is or the likely suspects in this case. That the notice under section 35(3) of the BNSS has been issued on the applicant may to a certain extent indicate that he is one of the suspects. Be that as it may, the full picture of the case or the progress of investigation is not presented before this court today. However, it would appear from the materials on record and the submission made that the applicant has indeed made out a case for apprehension of arrest. As far as consideration of grant of pre-arrest bail is concerned, this court has been guided by precedents as well as authorities. mostly of the Honorable Supreme Court in this area. It may not be out of place to refer to the case of Gurbakh Singh Sabia versus State of Punjab, reported at 1980 to SCC 565 at para 35, wherein the Honorable Supreme Court had clearly indicated that apprehension of fear of arrest cannot be mere fear, but has to be based on substantial evidence. In this case, this court would agree with the General Counsel for the applicant that, considering the relationship between the applicant's company and the complainant's company, that element of apprehension is present as far as the FIR lodge is concerned. As far as the allegation made in the FIR is concerned. Next. It is also true that this court, while considering prayer of this nature, is guided by parameters and guidelines found in authorities issued by the Honorable Supreme Court from time to time. Nature and gravity of the offence and such similar consideration is to be looked into while granting or refusing prayer made in that respect. Again, the case of Siddharam Satlingappa Maitri versus State of Maharashtra, found in 2011-1 SCC 694 at para 12 are some of the parameters laid down by the Honorable Supreme Court, which are reproduced here in below as argument. In view of the above observation, this petition is accordingly allowed. The applicant, in the event of his arrest, is to be released on the following condition: that he shall not abscond or tamper with the evidence and witnesses, that he shall cooperate with the IO as and when required, that he shall not leave the jurisdiction of India, during pendency of the investigation or trial, if it comes to that, that he shall bind himself on a personal bond of 50,000 with one surety of like amount to the satisfaction of the competent court of jurisdiction. Anything else? With the above, this petition is hereby disposed of.
I'm good.
Item number 3.
May it please the lens. This matter pertains to the CMJ University, my lords. The university, as my lords are aware, was directed to be dissolved by the state government, my lords. The spate of litigation matter travels ultimately to the Honorable Supreme Court. The Honorable Supreme Court, my lords, also in the month of January 2025, holds that, my lords, the decision to dissolve the university is perfectly okay. However, my lords, there is a caveat that's put in that it has to be done in terms of law. That's naturally, my lords. I draw your lordship's attention to the act itself, my lords. So, because my entire foundation of my case is on the basis of the act. If my lords may, if I may draw your lordship's attention to page 137, my lords.
Yes. Yes.
My lords would have seen the dissolution of the university.
137.
137, my lords. Section 48 of the act.
48. Yeah. Oh,
My lords have it.
Yes.
My lords, may I just read subsection 2 and subsection 3? I'll read section 48, my lords, for the convenience of all of us. If the sponsor proposes dissolution of the university in accordance with law governing the constitution and incorporation, it shall give at least 3 months' notice in writing to the state government. Not relevant for our purposes, my lords. Subsection 2 is what it has been done on. On identification of mismanagement, maladministration, indiscipline, failure in the accomplishment of the objectives of the university and the economic hardships in the management systems of the university, the state government would issue directions to the management system of the university. If the directions are not followed within such time as may be prescribed, the right to take a decision for winding up the university would vest in the state. That power has been exercised. Challenged, my lords, at various levels, matter retains finality with the judgment of the Honorable Supreme Court. I'll take your lordships to the judgment of the Supreme Court as well. Now, subsection 3 is, my lords, what I am concerned with. The manner of winding up the university would be such as may be prescribed by the state government in this behalf, provided that no such action will be initiated without affording a reasonable opportunity to show cause to the sponsorer. So, my lords, when the dissolution process is underway, first, my lords, a show cause notice has to be given to the sponsorer. Sponsorer is to, my lords, point out what is the my lords, objections, if at all he may have any, to the dissolution process. Not on the dissolution, on the process, my lords. And to that extent, they will consider and then move forward. Subsection 4 also becomes very relevant for our purposes. My lords, may kindly have a look. On receipt of the notice referred to in subsection 1, the state government shall, in consultation with the AICTE, UGC, or other regulatory bodies, make such arrangements for the administration of the university from the proposed date of dissolution of the university by the sponsorer, and until the last batch of students in regular courses of studies of the universities complete their courses of studies in such manner as may be prescribed by the statutes. In essence, my lords, the career of the students should not be made to suffer. The management would be removed. There would be an administrator appointed, and only for the time period during which, my lords, the last batch of students finishes off their course. That's the limited issue. Now, after the decision of the Honorable Supreme Court, my lords, the state government issues a public notice. That is what we are aggrieved with, and we are here before your lordships with that. My lords would find that public notice at page 389, my lords.
No, Mr. Paul,
My lords.
this mode and manner of winding up,
My lords.
is it prescribed or is it to be formulated?
It is to be formulated, my lords.
Not that.
Reading of subsection 3 is to be formulated, which is why I take your lordships to the public notice.
That's not. It was.
It's not laid down in the
it was
act
not
itself.
supposed to be so.
My lords.
What page?
I'm sorry, my lords. 389. If my lords kindly have a look at page 389. My lords, before that, may I very quickly just take your lordships to the conclusions of the Honorable Supreme Court, my lords. My lords would find that at page 385.
Yes.
Well, let's have conclusion, para 69. The issues raised for consideration of this court are answered as follows. The procedure prescribed under section 14 of the Act for appointment of Chancellor was not duly followed by CMG University, and consequently, the appointment of Chancellor of CMG University was non-est and void ab initio. The dissolution order dated 31st March 2014 has been passed with strict adherence to the procedural requirements outlined under Section 48 of the CMJ University Act and in compliance with the directions issued by this court in its order dated 13 September 2013, passed in SLP number so-and-so of 2013. So, to that extent, well, the Honorable Supreme Court, the division bench of the High Court was not, we need not go into that. That's pertaining to the list that was prior to the judgment of the High Court. Supreme Court says, it's not appropriate because division bench of this court, had remanded the matter back to the learned single judge for consideration. That was challenged in appeal. They said, did not require to go back to the single judge. Matter could have been decided at that stage. I'll now take your lordships to page 389, The typed copy of the public notice is at page 389.
Yes.
My lords have 389. This is, my lords, notice of winding up of CMG University invitation for claims and objections dated the 26th of March 2025. Whereas the Government of Meghalaya through the Education Department has issued an order dated 31st of March 2014 for dissolution of the CMG University by invoking the power specified under Section 48 of the CMG University Act. Whereas the Supreme Court, through its judgment dated 13th February 2015, has passed a ruling in favour of the Government of Meghalaya and has upheld its order for winding up of CMG University. Whereas by a notification dated 20th of February 2025, the Government of Meghalaya, through the Education Department, orders of the Governor, has appointed Shri D. Lingdo, Joint Secretary to the Government of Meghalaya Education Department, as the Administrator of CMG University, Meghalaya. 48(4), my lords, would recollect. Administrator is to be appointed. Then, my lords, this is for general public information hereby given that the administrator of Chandramohan Jha University, GS Road, Jorabat, Meghalaya, has commenced the process of winding up of its operations in pursuance of the Supreme Court of India judgment dated so-and-so, in exercise of the powers conferred by Section 12 of the Meghalaya Private Universities Regulation so-and-so Act 2019 and the provisions of the UGC guidelines. This notice serves to inform all stakeholders, including but not limited to students, faculty, staff, creditors, suppliers, alumni, and the general public of the university's decision to cease its operations. In order to ensure a fair and transparent winding up process, all persons or entities having claims or objections against CMG University are hereby invited to submit their claims or objections along with supporting documents within 30 days from the date of this notice, that is 25th April 2025. Well, then it says claims must be given to whom, submission details, important information. May kindly have a look at serial number 3. Claims and objections received after the stipulated deadline may not be considered. The university or its authorized representative reserves the right to verify all claims and objections and to seek further information or clarification as deemed necessary. This notice does not constitute an admission of liability as per the CMJ University. The winding up process will be conducted in accordance with the applicable laws and regulations. Students are advised to collect their final official transcripts and other academic documents. All creditors are advised to submit proof of debt. Then there's a disclaimer, my lords. This public notice is issued for the purposes of informing the public and inviting claims and objections in connection with the winding up of CMG University. This notice does not constitute legal advice. For specific legal advice, please consult with qualified legal professional. My grievance is, my lords, under 48(3), as your lordships would have seen, prior to the initiation of the winding up process, my lords, there has to be a notice under the proviso given to the sponsorer. The definition of sponsorer, my lords, would find at the Act at page 115. My lords, I'm sorry. If my lords kindly have a look at page 120, my lords. 120, section 2 of the Act. It is 2 Roman 33. My lords would have seen, my lords, sponsorer means the CMJ Foundation. So, my lords, after your decision to wind up has been upheld, you have started the process. Administrators appointed out for your lordships. Now, the foundation has to be heard. The reason why the foundation has to be heard is, my lords, that all the degrees that were there given to the students over the period of time, or the people who are now pursuing courses, because it was operational till, my lords, the 13th of February, these people have to be protected. That is the mandate of the Act. Otherwise, also, if your lordships would have seen section 48(4). Irrespective of whatever is the issue, my lords, the students may not be made to suffer. It is for that limited extent, my lords, we are here before your lordships. Because insofar as dissolution is concerned, my lords, that has to be done. It's been upheld. Matter has attained finality. I cannot do anything about it. The process of dissolution, my lords, the sponsor who set up the university, my lords, has been taken into consideration. Lordships would have seen in the public notice that compliance to the proviso to section 48.3 has never been done. Even though the administrators began the entire process, it was a prerequisite that you do that, hear them out, and thereafter proceed with the procedure. That would protect the students who were there. If my lords kindly have a look at my prayer as well, why I am here before your lordships. My lords would have a look at page 108.
Yes.
Well, it's appropriate issue writ of mandamus on appropriate setting aside the public notice dated 26/3/25. This is the notice I pointed out, my lords. Issued by so-and-so, by which the state government started the process of winding up of CMJ University by inviting claims and objections from public without issuing notice to the petitioner under section 48.3 of the CMJ Act. And, my lords, more importantly, and other appropriate writ of direction, directing the respondent government to declare that the degrees issued by CMJ University to the students who had pursued their courses had pursued, are pursuing the courses from so-and-so to so-and-so between the dates on which the order of dissolution of the university was set aside by the single judge of the Honorable High Court in WPC number so-and-so. We just skip that. As the university was functioning in the interregnum without any complaint in view of the orders dated so-and-so, passed in so-and-so, 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 may be protected.
Don't you think this prayer is too premature?
No, it is premature, it's not premature because, had there been compliance of 48.2 proviso, there's no reason for me to come to court.
True. You see, as far as the issue of issuance of the public notice is concerned, perhaps the court may look into it. But as to maneuvers for,
that my lords would consider after they come up with an affidavit saying what is the procedure that they will follow. At this stage, my lords, the reason for taking your lordships through the prayers is, my lords, why I am before your lordships, because this is, my lords, one of those cases where my claim has been defeated before the Honorable Supreme Court. So I would have to establish my bona fides before your lordships even before anything else. So I am simply saying, my lords, dissolution is already ordered. Procedure of dissolution 48.3 provides, my lords, there should be a notice. There has to be compliance of the regulations. And, my lords, my concern is that in the process of dissolution, my lords, the interest of the student should be protected. That's all.
Yes.
I'll accept notice, on behalf of all the respondents.
All the respondents?
All respondents, 4 respondents. And as far as
Mr.
section 48.3 is concerned, that's a closed chapter. 48.3 is a closed chapter.
But have you...
That was the issue.
Initially, have you issued notice upon him?
Yes, my lord. 48.3 is a closed chapter. That has been decided by the Supreme Court.
He is the sponsor.
48.2 is dissolution, my lords. If 48.3 had been closed, where's the reason of a public notice?
I'll file the affidavit, my lord. I'll bring everything on record. 48.3 is a closed chapter, my lord. And as far as the students is concerned, my lord, as on date, no decision has been taken by the government as yet, my lord. So this writ petition is premature, my lord.
Let it come by way of an affidavit. Let it come by way of an affidavit. Problem is, my lords, if the government takes a decision, my lords, if I may use the expression whimsical, what would happen is it would open up a Pandora's box of litigation all across the country. It would preempt this entire thing, my lords, that because there is an order of the Honorable Supreme Court as well, my lords, way back in 2013, which your lordships have seen fine mentioned in the final order, and my lords have dealt with this matter also. It says that, my lords, the case of the student should be considered sympathetically.
Oh, like I said, that's a different aspect of the matter altogether.
Logic.
Now we are only on the
48.3.
only on the mode and manner of
Dissolution.
how the process of dissolution has been carried out, whether it was proper or not.
Logic. Let them file an affidavit, my lords. Things will be clear.
Even that stage has not come, my lord. We just started the process, my lord, pursuant to the judgment, my lord. We have just called for claims, my lord, from the general public and the students and faculty.
Therefore, you see, at the outset, I had made a query as to whether it's a formulated, format or prescribed one, or it has to be devised by the authority under the relevant provision.
Which is why, my lords, there is an.
We'll answer, my lord.
Which is why, my lords, 3 comes in. Lordship is absolutely right. If it is already formulated, my lords, then there is no occasion for 3 to come in. Because it's not formulated, my lords, and it has to be formulated by them, therefore 3 comes in.
Heard Mr. Senior Counsel, appearing for the petitioner.
Show me the MS case here.
Who has submitted that on being aggrieved by where's that public notice again? Page?
My lords would find the public notice at page
389.
389.
Kununto? By a public notice dated 26 March 2025, issued by the
Respondent number 4, my lords.
respondent number 4, public administrator.
Yes, my lords.
Appointment of administrator, my lord.
No. 389 is not appointment of administrator.
Administrator of CMJ University.
My lords.
As regard the process of winding up or dissolution,
But this is just calling for claims and objections from the general public, including the students, faculty, anybody, my lord.
no, but subject matter is what?
My lords, the subject is notice of
dissolution.
winding up of CMJ University in invitation of claims and objections. Right on top, my lords, would kindly say.
Under the caption, I quote, notice of winding up of CMJ University and invitation for claims and objections. Close. Tapuli biang di mo. Katu, baca mo. Petitioner being aggrieved on the ground that relevant provision of come again,
Section 48.3, my lords.
where is it?
My lords would find section 48.3 at page 137, my lords. The proviso to section 48.3. 137, my lords.
7. Read the last line one more.
They didn't give, I asked them.
Of the CMJ University Act 2009, more particularly subsection 3 of section 48 of the same, not being complied with, has approached this court with a prayer for necessary direction to the concerned authorities in this regard. Mr. Leonard, you are Leonard
Special counsel.
Special Counsel. Leonard Special Counsel appearing for all the respondents. How many respondents are?
4 minutes.
4, my lords.
All the respondents herein have submitted at the bar that he is authorized to appear before such appear on behalf of such respondents and has accordingly accepted notice. On consideration of the submission made, this petition is accordingly admitted as has been stated above. Notice, formal notice on the respondents 1, 2, 3 and 4 respectively not required to be issued. The petitioner is directed to furnish copies of this petition upon the direct special counsel for the said respondents. Mr. Philemon Nongri has then submitted that he may be allowed to file the affidavit in opposition on behalf of the said respondent. Pray allowed. This is matter up to 2 weeks.
2 weeks. Let it be 3 weeks.
3 weeks.
Lengthy matter.
Well, it's there is a miscellaneous case as well, but I cannot press it at this stage. I'm praying the Lordship may issue notice on the same matter also. Once the affidavit comes, your Lordship will hear.
But he would accept notice.
Well, it's only issuing notice on the miscase as well. There's an application.
I will
for
accept
stay.
notice on the miscase also.
Miscase also. Lordship may kindly issue notice on the miscase as well.
तो का miscase है. Mr. Paul has submitted that notice may be allowed to be issued on respondents as far as this case is concerned. Mr. Philemon Nongri, Learned Counsel and the Special Counsel has submitted at the bar that he is competent to accept notice on behalf of such respondent and has done so accordingly. This application along with the main petition after 2 weeks.
Yes, I'll oblige.
2 and 3 into 3.
Daily list item number 1.